Now, the title of these lectures is Philosophy of Law. And we have a first question there's something else I wanted to say. These are lectures on philosophy of law. As you might know, philosophy of law, it is, yes, welcome. No. As you may know, philosophy of law, the science of philosophy is dialectic. So it means discussions. And it means that if you have any question to ask, provided you ask the questions in English, you are welcome. And we can have even debates between us about some of the questions which will be exposed by me. So an English course for French, it's not only supposed to be heard by the French, but they have to speak in English if they feel like doing it in order to improve their own English. Now, for the foreign students, it's something else. Most of the foreign students, they know English very well, and they choose these lectures because it helps them to have the lectures in English. So this is another matter. But for the French, they choose this lectures, to have little lectures in English and to improve their English and to get some points at the exams too. Yes. So if you want really to improve your English, you have to speak. So you are allowed to speak. You just raise your hand and say, "Sir, I have a question." And we can speak. Okay. Now we have a problem with the title of this course because it's philosophy of law, and as you may know, it's not always the words which are used in English to describe this field. Sometimes the books are speaking about philosophy of law, but sometimes they are speaking of legal theory, of law theory, or of jurisprudence. So we have first problem. Are all these words describing the same field, the same science, or legal or law theory is something different than philosophy of law? So this is the first question we have to answer in this general introduction. So we have to wonder what is philosophy of law, and then to examine what is legal theory. First question, what is philosophy of law? Second question, what is legal theory? And third question, if legal theory and philosophy of law are somewhat different, how are we going to make our choice? Because we have only 24 hours, and we cannot deal in 24 hours on two different sciences. We have to make a choice. So to make the choice, we have to know what is philosophy of law and what is legal theory. Sometimes they say legal theory, sometimes they say law theory, sometimes they say jurisprudence. political scientists, they use often the expression legal theory or law theory. Philosophers, they like better to speak of philosophy of law. And then lawyers, they are speaking about jurisprudence. So as you may guess, the difference between all these expressions reveals a different of approach. So it's very clear we are going to speak about the fundament of law, the fundament of right. But there may be a different way to reflect on these fundaments. The philosophers, they speak about philosophy of law because they think law theory is a part of philosophy. The political scientists or the lawyers, they speak about legal theory, law theory, or jurisprudence because they think this is a science which belongs to the field of law and not to the field of philosophy or philosophy. So I can simplify by saying that the philosophers think that philosophy of law belongs to philosophy, but the lawyers and the political scientists think that this science belongs to law, and that's why they speak about legal theory, law theory, or jurisprudence rather than of philosophy of law. Now, let's start with philosophy of law. Now, there are two words in philosophy of law, philosophy and law, okay? And philosophy, this is a very old Greek term, and as your friends from Greece know perfectly, philosophy, it means love of wisdom, love of science, love of wisdom. In Greek language, science and wisdom is the same word. It's Sophia. Sophia means science, but it means also wisdom. So the Greek don't make any difference, the old Greeks, they don't make any difference between science and wisdom, because the wise man is somebody who knows. So Sophia in Greek, I have to write it in the chat now, I guess. I don't write it in Greek. I can, but I don't think it will help the students who are not coming from Greece. So Sophia, it means wisdom, and it means science. So the wise man who possesses wisdom, he possesses also science. And in Plato tradition, the most important philosopher in old Greece, it's Plato. In Plato tradition, philosophy love of wisdom is linked with truth. So somewhere in the Republic, this is a very famous dialogue from Plato, somewhere in the Republic, Socrates, well, it's a dialogue from Plato, but the hero of the dialogue, it's Socrates, okay? And Socrates says something like this, there is nothing more related to wisdom than truth. There is nothing more related to wisdom than truth. So he makes a very narrow link between wisdom and truth. So as the philosopher is in love with wisdom and science, he is in love with truth. It doesn't mean that the philosopher possesses the truth, but he's looking, he's aiming at the truth. Now, in the expression philosophy of law, we have two terms. The first guy who used the word philosopher, maybe you know who he is Pythagoras. He was asked by somebody else what was his job or his occupation. And he answered, I'm not like the people who are seeking money or fame. I'm a philosopher. But then the word philosopher was very much used by Socrates and by Plato, and then by Aristotle and the other philosophers. Now, philosophy of law. If we apply the definition of the philosophy we explained before to the field of the law, it means that in philosophy of law, we have to look for the truth in law. What can be the truth in law? Well, it means that beyond the positive law, beyond the human laws, we have to think what is really law. Or in other words, what does justice really means? Law is related to justice. So if we are going to seek, we have to seek the truth in law. The truth in law is justice. What is justice? It means that justice may be something else or something beyond the human laws, the positive laws. Of course, we have laws in France, we have laws in other countries, and the laws are different. They are different in the space, and they are different in the time. So how we can find a truth in changing laws? Because what is justice today, according to human law today, maybe not be justice tomorrow if the law changes. So it means we have to find about something which doesn't change and which can be called justice. This is the meaning of truth in philosophy of law. The philosopher is seeking the truth, and in philosophy of law, he is seeking the truth in law. The truth in law is justice by itself. the essence of justice, justice by itself. And justice by itself may be something else, or at least something beyond the human laws of the positive laws. This is Plato's point of view. Plato is very important, as you may know, in philosophy. So Plato wrote one very famous dialogue. It's Republic. Republic has 10 books. It's a very long dialogue. But the first books of the Republic are dealing with the problem of justice. What is justice? And Socrates, who is the hero of the dialogue, is searching with the others, people which are in the dialogue, is searching a definition of justice. A definition of justice which is different from the positive law, from the human laws, or which can be different. In other words, it's not because we must respect a human law, a positive law. It doesn't mean that this human law or this positive law is this human law or this positive law express justice. It could be unjust. So we have to find the definition of justice in which the law will be contained. This is the point of view of Plato. As you may know, Plato is the founder of the theory of the ideas, intelligible forms. So he thinks that the realities are not what we know by experiment, but the reality are ideas which are beyond experience. For instance, if Plato sees a horse who is running in a field, for Plato, this is not the real horse. The real horse, it is an essence of the horse, which is always the same, which is universal, and to which the horse which is running in the field is participating. Now, you are going to explain me, but back with the horse, this is not very interesting. Let's come to justice. But there's the same problem with justice. As I told you before, if you take justice, justice is not the sensible justice, the justice as we know in experiment, the positive law, the human laws, the law, the justice, it is something which is beyond. Like the idea of the horse is something which is beyond the horse which is running in the field. Justice by itself is something which is beyond the justice of the laws, the positive of human laws. Now, I'm not telling that, I'm not saying that all the philosophers are like Plato, but Plato is the founder of the metaphysical tradition. And this tradition, this metaphysical tradition, is yearning for a definition of justice which is not contained in experiment in the sensible world, but it's something intellectual which is beyond the sensible world. We have something in Kant Kant, it's not Plato, of course, but there is something common between Plato and Kant. It is to look for a definition of the law, a definition of the justice, which is beyond the positive law. At the end of his life, he was 74, something like this, 73, 74. Kant wrote a book, the title of which is First Metaphysical Principles, First Metaphysical Principles of the Doctrine of Right. First Metaphysical Principles of the Doctrine of Right. It's not a book about, it's a book about individual right, but this is not the sense in the title of right. I'm not speaking about individual rights. I'm speaking about right in general, generally speaking. So this is the title. I translate the German title. And in this book, Kant drew a very famous distinction. He drew a very famous distinction between two different questions. The first question is, what is right? Or if you like better, what is law? But he writes, what is right in German? Was ist Recht? Right? This is the translation in English. There's no translation in English because it's not very easy to translate in English. So let's say right. This is right, but with a capital letter. What is right? And this is the question, which is a philosophical question. This is a question to which the lawyer cannot answer. Because, says Kant, the lawyer is like if we ask him what is law, what is right, generally speaking, he cannot answer because he is not competent to answer this question. Why? Because the lawyer is just like somebody who is a specialist in logic. When you are dealing with logic, you are not able to answer if the proposition of logics are true or not. This is not a problem in logic. You just have to get the proposition logically links one with the another. But the question about the truth is not a question of logic. Now, in law, in right, it is the same, says Kant. The lawyer, he has to deal with the right in the experience. So he have a case which he has to solve, and in order to solve this case, he used the human law, the positive law. He looks, he reads his code, or he reads the decision of courts, and he will answer the question in a case how the law or the courts are solving the problem on which he is dealing. This is the task of the lawyer. Now, It's not because he's able to answer in a case how the case should be solved. It's not because he's able of that he knows what is right, generally speaking, right by itself. Because right by itself is a philosophical question. So the question the lawyer answers is not what is law, what is right, sorry, what is right. The question the lawyer answers is not what is right. The question the lawyer has to answer is what is legal. I'm translating the German, it's not very easy, but this is how we could translate the second question Kant is speaking about. He says there's a first question, what is right, generally speaking, and the second question, what is legal? The task of the lawyer is to ask the second question. What is legal? So you have a case which happens, and he has to respond to the question how to solve this case regarding the code, the decision of the courts, etc. But the question, the following question, what is right? What is justice? He cannot answer. He is not able to answer because he has only empirical principles which he deduced from the code, from the decision of courts. He is not competent to answer these questions. He has not the power to answer these questions. And even he may not answer this question. He is not allowed to answer this question because the lawyer, he must respect the positive law. He has not to ask himself whether the positive law is just or not. It's not his task. He has to obey the laws and to solve the cases in experience regarding these laws. He cannot discuss about the justice of laws. If he would do so, he would do something which is not his task. The lawyer is just a workman, says Kant in another work. He's just a workman. He's an ouvrier. He's a workman. He must, like a workman who is building, for instance, a car, he's building, he's resolving cases with his science, but his science is just an empirical science, which is deduced from codes and decision from codes. Now the question, what is law? What is right? Sorry, what is right? This is a philosophical question, and it's up to the philosopher to answer this question. So what is very clear in Kant's thought, it is that philosophy of law is a branch of philosophy and not a branch of law. Because philosophy, what Kant calls metaphysic, philosophy is the supreme science, the science above. And the fundaments of law are deduced from philosophy and not from law. The lawyer, he must he can only execute, apply the human laws, and that's all. He's here to apply, but to appreciate if the laws, the positive laws, are just or not, this is the task of the philosopher. So Kant wrote this in the Doctrine of Right, the book I quoted some 10 minutes ago, but he wrote this also in another book, which was his last published book. It is The Conflict of the Faculties. The Conflict of the Faculties. The conflict of the faculties, it's a conflict between the different faculties, the different university. You have universities specialized in law, universities specialized in philosophy, universities specialized in history. And what Kant explains in this book, The Conflict of Faculties, it is that the faculty of philosophy is the top one. Because it's only in the faculty of philosophy that people, philosophers, can freely search the fundamentals of everything, and especially the fundament of law. In the University of Law, Faculty of Law, the students are just learning how to apply the human law to the cases. They are just technicians, workmen. Now, that's not very flattering for the lawyers, understand? So the lawyers don't like very much Kant because they understand that Kant is telling them, well, I'm sorry, but you are just inferiors. We philosophers are the only who are going to reflect on the fundamentals of law, and you are only here to apply law. That's all we ask to you. Now, Kant doesn't use the word philosophy of law. As I told you before, he speaks about first metaphysical principles of the doctrine of right. But now, about 30 years later, there is another German philosopher, Hegel, and Hegel is the first to use the word philosophy of law, or philosophy of right. It depends on how we translate the German title. Anyway, in 1831, Hegel wrote a book, he published a book, the title of which was, how could I translate this in English? The title usually, the usual title in English is Philosophy of Right. Philosophy of Right. But it's not the exact German title, the exact German title. In German, it is first principles or principles of philosophy of right or of law. I cannot say because the word Hegel used is Recht. Also in English, we can translate by law or by right. It depends what we are going to say. So usually, the English translators are giving the following title, Philosophy of Right. Now, Hegel is the first to have used the expression philosophy of law or philosophy of right, which became later very popular. But it doesn't mean that the philosophy of law began with Hegel. The philosophy of law has always existed. It was always a part of the reflection of the philosophers in Greek times, old Greek times, and in modern times. There is a philosophy of law in Plato. There is a philosophy of law in Aristotle. There is a philosophy of law in Hobbes, or in Locke, or in Kant, of course, even if it was not the expression which was used by these philosophers. And in this book, Philosophy of Right, Hegel expressed also Kant's distinction between what is right and what is legal. Kant inspired him in this distinction. Hegel writes in the introduction of the principles of the philosophy of right, he says, there is a science of law which is part of philosophy. There is a science of law which is part of philosophy. And besides the science of law, which is part of philosophy, there is a positive science of law. Now, it is only the science of law, which is part of philosophy, which deals with the question of the law, generally speaking. The positive science of law, it deals only with particular matters, with cases. Now, it means that Hegel, like Kant, thought that the lawyers have to stay in their field, is to apply laws in particular cases, but when it's about reflecting about the fundamentals of law, only the philosopher can do this. And Hegel had something like, he wrote, and he had remarks on the footnotes of it. And in the footnote, Hegel says, well, the relation between science of law, which is a part of philosophy, and positive science of law, it's a little like the relation between the institutes and the digest. You know these books, Institute and Digest, sorry, Institute and Digest. Well, you know that all the Greek laws and opinion of the lawyers were collected by Justinian in a book, the title of which is Corpus Juris Civilis. And in this Corpus Juris Civilis, there are 4 books, and 2 of these books are the first, the Institutes, and the second, the Digest. And Hegel says, look, this is exactly the same relation between the institute and the digest than the relation between science of law or science of right, part of philosophy, and positive science of law. Because the institutes, in the institutes, we find the fundaments of law, the principles, and the digest, it deals only with peculiar cases. So the distinction between institutes and digest is the same distinction which exists between science of right or science of law and science of positive law. Now, of course, Hegel was wrong, because the digest is not the application of the principles which are in the institute. Maybe you know this book, you have heard about these books. The institute is just a scholar book. It's for students. So it's an abridged book. And the digest is not a book of application. It's a more developed book than the institutes. So it's not true to say that the digest applies the principles which are contained in the institutes. The principles are contained in the institutes, but also in the digest. But the digest is a scientific book, and the institutes are only a book for students. Now, the lawyers, when they read what Hegel wrote, they say, haha, that's it. When a philosopher pretends to deal with the law, he says something wrong. Why Hegel was wrong? Because he doesn't know anything about law. And what does it mean? It means that a philosopher should not deal with law, even with law in general, because he doesn't know laws in particular, so he cannot know what is law in general. So the lawyers, they say, the problem with Kant and Hegel, they are built science of law, a philosophy of law, which has nothing to do with positive law, because they don't know positive law. They are ignorant. And that's why we have, besides philosophy of law, legal or law theory. Legal or law theory or jurisprudence is another title given to the science on which the lecturers are dealing, but it's another title which is given by lawyers or political scientists. And it means that the lawyers and the political scientists think they can reflect on the law without the help of the philosophers. Because they say, look, who is knowing the law? We are knowing the law because we are lawyers. This is our job. We are studying laws from 18 years old. We have studied law. So we know law very well. And that's why we are competent to reflect about the fundament of law, to think the fundamentals of law. Because to think the fundamentals of law, one must know what are the positive laws. If you want to build a theory of law without knowing the positive law, you are going to build a science which has nothing to do with the real law, and the real law is the positive law. This is the point of view of the lawyers and the political scientists. And this explains that these people have chosen to call the same science than the philosopher, not philosophy of law, but legal theory or law theory or jurisprudence. Now we can have a break of 10 minutes before starting again. So let's have a break. Any question? Question after the break. Because before we go further, have you any questions? Something which is not clear and you wanted me to explain it. Yes. Sorry. This is not about what I explained. This is something else. Exam. Yeah, there will be an exam, of course. No, it will be a written exam. This is the rule for all the lectures in English. And the written exam will be several questions on the lectures. And you will not have any access to any documents. The duration of the exam is 1 hour and a half. Yes.
Are they open or?
Are they open or what? Not you know, it's not like something like Nietzsche was the son of Plato, was the father of Socrates, was the cousin of Kant, and you have to give a quite you have to choose. Yes, this is not the kind of question. This is when I say several questions, it could be 3, 4, 5 questions, and you have to develop. You have to expand about the question, not answer only with one sentence. The written exam will be, I don't know, in May, I think. Maybe in May, I think. In the end of April or beginning of May. Yes? It's only handwritten because I have to correct. And if you could use the computer, you could have access to internet, and it would be possible to check that you have answered only with your knowledge. So this is not possible. It must be written, and that's all. Now, on Agora Asas, I didn't work a lot on Agora Asas. You could you can check, but I've given a bibliography. But this is a very it's a bibliography at random. So there are a lot of books which are in this bibliography and which I don't know. I only checked it were available, but I don't know them. what I can tell you about this biography is the following. First of all, when I speak about classical philosopher, Plato, Kant, anybody else, you can get access to the books on several websites. For Greek philosophers, it's Perseus, the first one here. You have the books, of course, in Greek, but you have also English translations. Now, there is another website which is very famous. It's Gutenberg. Gutenberg, this is a free, it's a open source, and you can go to Gutenberg and read online or load the book you need. It's about philosophical books or other books. There are a lot of philosophical books translated in English. For instance, Kant, Plato, or Hobbes, but Hobbes he wrote in English, so no problem. And it's all free. And then there is a last one, which is a little like Gutenberg. It's classic. Now you have printed books if you want to spend money, or printed book you can find in Cujas, for instance. The first of the books, I know it quite well. This is Friedman, Legal Theory. This is a very good book. This is the 5th edition, Legal Theory, 1967. But this is a book which is sold, and it's sold quite expensive. So it's not worth buying it, but you can borrow it in Cujas. And moreover, you have a website which is quite famous. This website is archive.org. On this website, you can find not the 5th edition, not the last edition, but the 4th edition. He changed quite a lot of things between the 4th edition and the 5th edition, but it doesn't matter. It will not disturb you. So if you want to read explanations on philosophy of law in English from an author who taught philosophy of law in the United States, so he's a native speaker. Maybe he's from German origin, I don't know, but he wrote in English. So this is a very good book. The other books, I don't know them. If we speak about the books which are classified in philosophy of law in general, I know Friedman. The other books, I don't know them. I think they are not so deep like the books, Friedman's book. Friedman's book is very good. Now, there are books translated in English or written in English, which are I would say very scientific, and I give you the titles, but you are not obliged to read them, of course. Among all these books, there is a very famous book from Werner Jaeger, Paideia, he was German, but he flew to United States before the war, and he wrote Paideia in English. No, he wrote it in German, but it was immediately translated in English. This is a very famous book, very good book. And then you have another book you can find, I think, on Gutenberg. It's an old book from a Greek author, Diogenes Laertius, and it's Lives of Eminent Philosophers. It's not a scientific book. It's just a book which is full of about tales about philosophers. But we get in this book many information on Greek philosophers, which we do not find elsewhere. I mean, of course, we are speaking in Greek philosophers about Plato. We have almost all his dialogues. But there are many philosophers whose works are lost. And so this guy, this Diogenes Laertius, he wrote much later than the old Greeks, but in Greece, he wrote a book which was a book of vulgarization. So he was not a philosopher himself. He was just a guy who liked philosophy and philosophers. So he had some materials that we have not today. And he could give us informations about old Greek philosophers, which we don't find elsewhere. So you have free access to this book, I think, on Gutenberg or on Perseus. Then the other books are scientific books, which we are not going to read anyway. So they are in the bibliography if you are a little inquisitive, but I guess it will not be the case. The only book which is in French in this bibliography is a book from Jacqueline de Romilly. This is for the French students. This is a book every French student in law should have once read. La loi dans la pensée grecque. This is a very good book, and any French student should have read this book. It's very easy to read for French students. Now the other books are scientific books, and you have not enough knowledge to understand them, I guess. For those who have already read Plato, there is a very good book in English about the Republic of Plato. It's from Nethership. He was a very famous English scholar. It is on the bibliography. You haven't to read Nethership. You can find free access to his book. But if I explain something about the Republic of Plato you don't understand, and you go to the text translation in English, you still don't understand, you can use this book to better understand, in order to better understand. It's a very famous book on the Plato's Republic, Nethership. Now, this is all for the bibliography. Have you any question about this? I guess anyway, you are not going to read any of these books. It's just for help if you would have need to check something in one of these books. But of course, you have not to read them. Now, if you still have no question, we can go further with legal theory. Now, what you should understand is that legal theory which emerge as science which would be different from philosophy of law, because it's the philosophy of law of lawyers and not the philosophy of law of philosophers. The success of legal theory is part of a general spread of scientism. I mean that when we go back to the 17th century, there was a supremacy of metaphysics. Metaphysics, this is philosophy, and all the sciences were under the domination of metaphysics. Maybe you heard about Descartes' tree. Did you heard about Descartes' tree? We're going to speak later about Newton's tree, but this is Descartes' tree. So, in a very famous, Descartes wrote a book which was destined to students. It was the Principles of Philosophy. But he wrote this book in Latin, because the language in which Descartes used to write was Latin, except for the Discours of the Method. The Discours de la Méthode was written in French, but the other books were written in Latin. So he wrote these Principles of Philosophy in Latin, and there was a monk who decided to translate this book in French. And he told Descartes, you have written a so wonderful book. Could you make a preface to this book? So the translation I give in French. And Descartes answered, well, I've not the time to write a preface, because Queen Christine is waiting for me in Sweden, and I'm leaving, and he died there. It was too cold in Sweden, so he died. So I'm not going to write a preface, but I can write you a letter which could be understood as a preface. So he wrote a letter of a few pages, and the monk was Picot, and he wrote a letter to Picot. And this letter is known as the letter preface of the Principles of Philosophy. In this letter, which is very famous, he described the philosophy as a tree. He says philosophy, it is a tree. And in the tree, you have the roots, and the root is metaphysics. So all the strength of the tree is from the roots. The fundamentals of the tree, it is the roots. So this is metaphysics. Now, in a tree, you have a trunk. And the trunk, Descartes says, this is physics. I must remind you that in the 17th century, physics was part of the philosophy. We are not yet at the century of Newton. And so physics was understood as a part of philosophy according to Aristotle's tradition. In the books from Aristotle, you have physics and you have metaphysics. So physics was regarded as a part of philosophy. So Descartes says, well, the roots are metaphysics. The trunk is physics. And now you have several branches of the tree, and the several branches are the other sciences like moral, like medicine, like mechanic. So what does it mean, this image? It means that in the Descartes century, philosophy was regarded to be the supreme science, the science which dominated the other sciences. That's why metaphysics was the root, physics the trunk, and mechanic, medicine, or moral the branches. Now the things changed in the 18th century. At the end of the 17th century and the 18th century. But what happens then? It was that the physics started to liberate itself from metaphysics. The physics started to liberate itself from physics, from metaphysics. This is the end of the 17th century. This is Newton. What did Newton? Newton was not, well, he was regarded as a philosopher in the 18th and 17th century. Newton was regarded as a philosopher. But now when we think about Newton, we think this is the founder of modern physics, okay? Modern physics as a science. Because what Newton did, he thought that nature could be understood by itself, not with the help of metaphysical principles, but with the help of mathematics and experiences, right? This is the famous apple who falls on the floor. Or this is just a fairy tale, but Newton says, this is the law of universal gravitation. So what Newton made, he tried to explain nature with the help of mathematics and not with the help of metaphysical principles. Now, there is a second thinker very important at the end of the 17th century. It is Locke, John Locke. John Locke was English, and he made approximately the same thing. He did approximately the same thing in philosophy than Newton made in physics. So what wrote John Locke? He wrote a book which the title of which is an essay on human understanding. An essay on human understanding. And in this book, he tried to explain from which our knowledge is induced. But of course, it's very short, and it's not. We are not going to discuss about Locke during hours, okay? But what Locke thought, it is that our knowledge is derived from experience. Our knowledge is derived from experience. All we know from experience, from sensation. From sensation, and he added from reflection about these sensations. So he didn't agree with Descartes. Descartes, before Locke, Descartes thought that our knowledge, we have this knowledge in ourselves. We have innate ideas. which are before the experience. That's what Descartes thought. But Locke thought, on the contrary, that all our knowledge is derived from experience. So we don't need metaphysics to understand things or the world. We need only experience. Metaphysics, this is just a dream. Now, this is the beginning of modern science. After the 17th century begins the 18th century. 18th century, this is, you know, of course, Enlightenment. Enlightenment, you know this word? Aufklärung, Enlightenment. Les Lumières. This is the 18th century. And the 18th century, in the 18th century, the thinkers, they recognize Locke and Newton as their masters. Because they say these people have understood that nature, knowledge, is derived from experience and not from metaphysical principles. We don't need God to understand the nature of the world. We need experiment. So this is the beginning of the decline of metaphysics. Yes?
To ask about questions like why the
metaphysics is everything which is beyond experience, okay? I said God because the war was, well, the 18th century was not against God, but they fought the thinkers of the 18th century like Diderot, like Rousseau, like Voltaire, or French thinkers. They thought that the world would be understood without the help of metaphysical principles. On the contrary, Descartes thought that we could understand the world with innate ideas. And why were these innate ideas accurate? It was because God gave us innate ideas. If you take the famous Descartes book, Metaphysical Meditations, he's asking himself, how can I be sure that my knowledge is accurate? And he reflects about this thing, and he says, well, there is something which I cannot doubt about. It is when I think, I exist. I think it means that I exist. I am. I think I am. Now, from this first truth, he goes to God and said, it is God who gave me the ideas which are accurate, which are truth. And these ideas which God gave me, I have to apply them in the experience. So for Descartes, the knowledge is not derived from experience. You have the knowledge before, and you apply it to the experience. On the contrary, with Locke, in philosophy, or with Newton in physics, your knowledge is induced from experience. This is the difference. So what is what are all the thinkers of the 18th century about what they are all agreeing, it is that nature can be understood by itself. Nature and the world can be understood by itself. We don't have to reach a metaphysical concept which are beyond experience. Metaphysical concepts are just dreams. Well, I'm thinking about Locke and the French thinker of the 18th century, because in Germany it was a little different. But in Germany, because in Germany, there is no influence from Locke. The Enlightenment, this was a thought which spread from England to France and to Germany. But in Germany, Locke didn't succeed, because in Germany there was another great thinker. It was Leibniz. And Leibniz thought, like Descartes, that the ideas, we have them in ourselves and we apply them to experiences, but we don't derive the ideas from experience. So Leibniz didn't feel like Locke. And Leibniz had a student whose name was Wolff. And this guy, Wolff, he wrote books of philosophy for students. And all the students of philosophy in Germany in 18th century, they had the books of Wolff books. So they were taught in Leibniz philosophy. So the empirical philosophy of Locke didn't succeed in England. That's why it didn't succeed in Germany, sorry. That's why you have the last thinker of the Enlightenment. This is, of course, Kant. Kant could not be born elsewhere than in Germany, because Kant, this is not an empirical philosopher. This is a philosopher who tried to restore metaphysics, where Kant could be born only in Germany, because in Germany, Locke didn't succeed. You have a very famous book. I don't know if it's translated in English. It is translated in French, about the Enlightenment. This is the philosophy of Enlightenment from Cassirer. The philosophy of Enlightenment. So now, what happened with Locke and Newton, and with the consequences their followers in the 18th century, what happened is that science began to liberate itself from metaphysics. I remind you that Descartes thought that physics was a part of the tree, the roots of which were metaphysics. Now, in the 18th century, following the works of Locke and Newton, most of the people thought that nature could be understood by itself from experience. And even if Kant in Germany didn't think so, I remind you, because I guess you know it, Kant was a philosopher who thought that God could not be proved. There was no proof of God. We can think God, but we cannot know God. This is one of very important principles in Kant's philosophy. Now, all these sciences liberate themselves from metaphysics, and it was the first science which liberated itself from metaphysics was physics with Newton. But in the 19th century, later again, 19th century, the other sciences than physics or mathematics started to pretend also to liberate themselves from metaphysics. What are these other sciences? History, psychology, sociology. In the 19th century, we see these sciences are developing themselves independently from philosophy, from metaphysics. And now, these are not sciences in the traditional meaning. This means physics or mathematics. These are soft sciences, history, psychology, sociology. And now, among these soft sciences, there is law. And so you have the same evolution in the field of law. What we see in the 19th century, it is that lawyers, like psychologists, like sociologists, like historians, want to liberate themselves from the supremacy of metaphysics. And this is the way legal theory appears. Legal theory appears for the first time in England. England, this is the country from Locke in the 17th century. And it's not very surprising that an empirical theory of law was born in 19th century in England. And the guy who founded legal theory as a science different from philosophy of law was called John Austin. John Austin, he wrote his books in the middle of the 19th century. Yeah. Now this guy, Austin, he was not a philosopher, of course. He was a lawyer. But he had the ambition to found a theory of law, to elaborate a theory of law. And he wrote several books, but he wrote mainly two books. And the title of the books are the title of the books explains very clearly what was his goal. The first book sorry, this is only one book with the first part, which was later published alone. It was a book, and the first part was later published alone. Now, the title of the book is Lectures on Jurisprudence. Okay, this is the word the lawyers are using to speak about philosophy of law. Lectures on Jurisprudence of the philosophy of positive law, of the philosophy of positive law. Lectures on Jurisprudence of the philosophy of positive law. And the first division of this book, which was later published apart, is entitled The Province of Jurisprudence Determined. The province of jurisprudence determined. So even if you have never read Austin, and it is no use to read Austin, he's a very poor author, not very interesting, but very famous. He has a historic importance, but his thought is very superficial. Sorry. Now, if you read only the title of these books, you understand that the purpose of this Austin, it was to elaborate law theory, which was restrained to positive law. He begins his book by saying that the only real law is positive law. Of course, there are thinkers from the past centuries who spoke about natural law, a law which would exist beyond the positive law. But Austin says, this is stupid. There are nothing such a natural law. The only law which exists, we know it, is positive law. So a philosophy, a reflection about law must take as object of its thought positive law. And this implies that there is a philosophy of positive law, as the title of the book suggests. There is a philosophy of positive law, which is different from the philosophy of law of the philosophers. The philosophers are just dreaming about a law as it ought to be. The philosophers are just dreaming about justice, about a law which ought to be. But the law as it is, this is the object of law theory, and it's a matter for the lawyers and not the philosophers. The philosophers are in the sky, they are just dreaming. They discuss about the law ought to be, or justice ought to be. But now the reality, it is the justice and the laws which exist, which are existing, so the positive law. So a science about the law in general must take positive law as its object. Very simple. No? Now, this way of thinking, this legal theory, spread from England to other European countries, Germany, Switzerland, Österreich, Austria, with Kelsen. You heard about Kelsen. He was a legal positivist. Austin was a legal positivist. Kelsen was a legal positivist. There are other authors in Germany, in Switzerland. In Switzerland, there is an author whose name is Roguin. In France, also, we have authors who defend this conception of law theory, legal theory, which relies on positive law to found the law in general. So this is a sign of the autonomy of law against philosophy. Law emerges as a science which is distinct of philosophy and which principles are in itself, are not to be borrowed to philosophy. Now, we are not going to speak about this today, but I told you that legal theory follows an evolution of the thought which begins at the end of the 17th century with Newton and Locke, and go further in the 18th century and 19th century with all the soft science who wants to be independent from philosophy. But it doesn't mean that this evolution has no old roots. It has old roots. The roots of this evolution are in old Greek thinkers on one part, and in an English philosopher on the other part. The English philosopher is Hobbes, and the Greek thinker I think about are the sophists. The positive law, the philosophy reduced to positive law, finds its roots on one hand in the sophists in the 5th century before Christus, and in the other hand, in the philosophy of Thomas Hobbes, who is an English philosopher of the 17th century. And this I intend to explain next week. Now, have you any question before leaving? Or you want to leave and liberate yourself from philosophy? Are there anything you didn't understand? Because English, that will be better later. I start again, but I know this English will improve. It's trusted, so that's why. So have you anything you didn't understand? Surely you have there are some things you didn't understand. I don't think it was so clear. It was? Okay, you are free. So the recording of the lesson will be on of the lecture will be on Agora SAS. If not, it will be on the website of the university in the podcast. As a matter of fact, on the website about the podcast, there are the lectures of last year, which are still recorded and still available. I pray the administration to let them online and give you free access. But I don't remember what I said last year. Maybe it was very different.